Morning, everybody. Welcome to an oral argument session at the 5th District Court of Appeal. My name is Dan Traver. We are being recorded and streamed on YouTube this morning. We have 3 cases set on our oral argument docket today. This is the first of them, case number 19-3301, Wendy K. White versus Cassie Jo Chin in Volusia County, Florida. I'm joined today by my fellow panelists, Judge Rand Wallace and Judge Mary Nardella. I will assume that counsel for the appellant would like 5 minutes for rebuttal, unless he tells me differently. And Mr. Ebbets, you may proceed.
May it please the court, Your Honor. My name is Charles Chobe Ebbets. I have the privilege of representing Wendy K. White, the appellant in this matter. Having practiced for 44 years and been before this court many times, I know the court is well briefed and thoroughly aware of all the facts in the case, so I will not bore the court nor reiterate things the court already knows, but I would like to briefly summarize in a very important way what I think went wrong here at the trial level. This case is basically, and most importantly, an exact duplicate in many respects of the seminal case of Ralph versus the City of Daytona Beach. And as you know, Ralph versus City of Daytona Beach, the Supreme Court of Florida recognized that if a city, in this case, the City of Daytona Beach, assumed control over a beach area, then it had a duty to warn of dangers associated with the driving on the beach mixed with, and this is important, the lethal, as they said in their quote in the court, the lethal mixture of cars and sunbathers, people sunbathing on the beach. Now, there is a whole host of cases involving other accidents on the beach, people in traffic lanes, people drowning in surf that we're not talking about. We're talking specifically about a sunbather who went to lay on her back, read a book with her headphones on, and then is run over by a car which crushed her lower extremity, a truck rather. We focused our case on that, and the county tried to dismiss the case for failure to state a cause of action, and in a very, in its own order, the trial court, the original trial judge said, no, this is a Ralph case, and importantly, it is also a Butler case. And I'll tie that together in a minute because Butler is a 1987 case, again, recognizing, in this case, the Sarasota County, when they assumed control over of a beach area that became a swimming area, then they had a duty to perform the task of supervising and controlling that area in a proper fashion. The Supreme Court again said that's an actionable cause of action. So the trial judge, original trial judge said, yes, this is a Ralph Butler case situation, go forward. The trial judge just made huge errors in both procedurally and substantively in the decision below. And it's completely apparent in, and again, I know the courts reviewed it, if the order itself writes words that says, I'm the judge and I am finding as a matter of fact, I'm concluding that because this lady had been to the beach before and knew there were cars on the beach, that's done. There's no duty to warn. In fact, in the transcript of the proceedings, she said, well, she can't even argue that she didn't know because she said she'd been to the beach before in the depositions and it wouldn't be credible for her to say that. Well, Your Honors, my esteemed colleague, Mr. Carroll, never asked, nor did any lawyer in the case ever ask the plaintiff in any deposition in this case, were you aware that if you were laying flat on your back with headphones on, looking up in the air in soft sand where only people were sunbathing and no cars were present, that a car might come up in there where you're sunbathing and feel safe and run over you? In fact, this testimony was she walked down from the beach. She'd parked not on the beach, but down from the beach and laid in the soft sand near a lifeguard, feeling she would be safe there. And at no time was she asked, well, were you aware of that inherent danger that if while you're lying there and not paying attention, reading a book or sleeping in the sand, you could get run over? No, she was never asked that. And that is the exact danger that could have been prevented here had there been proper warning. I took the deposition. I'm sorry. Yes, Your Honor.
What do you think the warning should have been in this case?
They could have had a warning sign. They could have, actually, I can do better than that. The warning should have been exactly what Captain Etheridge said they did. And I would refer to Captain Etheridge, who was the supervisor of the beach that day. And in his deposition, I said to him, do you warn the sunbathers of the cars coming up on the beach? And he specifically said, yes, we do. On pages, actually, there are 829. He says, I'm sorry, no, that's the record on appeal. He says in his deposition, yes, after the tide starts receding, because they close the beach. Let me give the facts really quickly. When they have the tide come up, taking over the traffic lanes, and again, these have been filed with the court. It's in the record, all the photographs. The truck came up into the soft sand because the tide was coming up and covered up the traffic lanes, and they closed the beach exactly at the time this thing happened. And so I said to Captain Etheridge, well, sir, what warning do you give about cars being there? He says, well, after the tide starts receding and we reopen the beach, we specifically warn the sunbathers, be careful, there'll be vehicles on the beach now. They would warn, be careful, look out, cars are coming at that stage, but they didn't do it as they are closing the beach or as people are coming on the beach. They could have done it a variety of ways. That's why they have the personnel there. And importantly, and I want to tie all this together because I think it's real important. This case comes after Ralph and after, interesting, the Coastal Zone Act. The Coastal Zone Act, Your Honors, and again, it's in my brief, specifically allowed someone like the county, and this is when we shifted. I know the court is comprised of people that haven't always lived here, but those of us that has know we've gone through this situation where different agencies, back in Ralph, it was Daytona Beach and it would be Port Orange, they'd all have their own little controls over their own little beaches areas and assume it. But then after the Coastal Act, the County of Volusia, because, and this is important, could control all of the beaches and charge for it. They then went into that mode of being the controller of all of the beaches. And that's when we have the toll booth set up. And that's when you and I and the other citizens have to pay a toll to get on the beach. And why do we pay that toll? And it's very important. In the enabling statute, it says, if you take control of the beach, you may charge a toll. For what purposes? For maintaining safe beach practices, law enforcement, and interestingly, acquiring liability insurance for those duties. Now, if the state legislature didn't believe that once they provided the entity the right to control it and the right to charge for that control, a concession, then they wouldn't have added that liability piece. But they recognize they're smart. Lawmakers make good decisions. This is good law. They said, if you're going to do it, you might want to get liability insurance because now you're operating a concession. And when you do that, and this is where the court also missed the point so vividly, the court grabbed, well, this is a category 2 try-on case, and this is just police powers. You're out, Mr. Ebbets. You don't have a case. The court didn't understand that it was not that at all. It was a try-on category 3 case, which clearly says when a public entity takes control of or maintains an area, it then has the same common law duty as an ordinary citizen. And that's where Butler kicked in. And so why is that important? Why is Butler important? Well, kind of putting this all together, Ralph was February of 1983, a pre-try-on case. Then Butler would come back afterwards and cite Ralph. But really what's important, Your Honors, and I've noticed this and I had not caught this before, clearly the Supreme Court never intended try-on to change the ruling in Ralph, because if you look at the citation itself and go to Ralph was heard in February and ruled in February of 1983, but the Supreme Court held back its rehearing, knowing that it had all these other cases lining up that could be affected by try-on. So the motion for rehearing was timely filed and not ruled on until 1985 by the Supreme Court, 2 years after try-on was decided that summer. So the Supreme Court understood how the law changed or shifted when try-on came out with now 4 categories instead of the old 2, planning and discretionary, and said, this case still is good law and has remained good law throughout this time. Then finally, the trial court below, that's why I said it's just a fundamental group of errors. The trial court below then embraces the county's position that, well, you can't sue us under any circumstances here. You're kicked out because of a Florida statute that deals with changing surf conditions, and therefore we can't be sued because this is a changing surf case. But as I pointed out in my brief, when you look at the statute and this precise words of the statute, it says caused by changing surf. The injury to my client was caused by a vehicle driving up on soft sand where she was sunbathing correctly, a la Ralph, expecting to be safe up in the soft sand, and a car drove up in there to cause her injury. The surf issue, or the tide, and even the court recognizes that surf is, if we look at the definition of surf, it's at the waterline. It is the foam coming up on the surf. And that's why the one and only case that deals with it, the Brown case, was a rip current case where a swimmer was out in that surf, caught in the undertow of the rip tide and drowned. And they said, no, this is what that statute's designed to do. This is an entirely different case. It has nothing to do with the application of the facts of this case. This case, the tide issue came up because that triggered, importantly, the operational duties in running this concession of a beach that the county had put in place by their own provisions, but recognizing they now have to run this beach. They're getting paid to do it. And they have toll takers giving money to us, or citizens giving money to the county so they can employ these law enforcement people, what they call the beach patrol, set up the safety standards, put the poles out. So back to the Judge Nardella's question, they would put cones out to mark traffic lanes. They would put markers in the sand to mark the soft sand, but they had no sign. We asked this, was there any signage about warning sunbathers of the danger of cars might come up in that soft sand when they're directed to go there? And this is important. In the transcript and in the testimony, the two officers said they direct the beach toll person, we're going to be closing the beach, tell the cars that are coming in at the end to get quickly up out of the water line. And honestly, going back to, or not honestly, critically going back to when the county was brought in, it's when the testimony of Ms. Chin, the lady that ran over my client, said, I was told to get up in the soft sand quickly by the people at the toll gate, by the county, because of the tide coming in. And so she was literally directed to do what she did. And again, something my client would have never expected. These photographs that I held up are important. Again, I want to hold it just for a second. That was taken right afterwards. And you'll see there are no, and again, my client said she saw no cars going up and down at the time. Other than the truck and other vehicles, there's no cars, there's no people there. There's only sunbathers. She was expecting to be in a safe area. The other photographs that, again, the court has in the record are the photographs immediately taken after. And these were by a bystander, again, in the record. And again, show very few cars, water line coming up. The lady came up quickly, as she was told to do. And then you see where tragically she ran over my client, where you see the bathing apparatus in the soft sand. So the court, trial court, prejudged the evidence and said, well, I think the lady cannot argue that because she knew there were cars on the beach, she should have been, didn't need to be warned of those cars. Well, if that's true, that was true back in Ralph. And if that's true, Your Honors, that means there never can be a case where a person that goes to the beach and is injured by a car can sue the entity controlling that beach under any circumstances, because there isn't a human being on the planet that comes to Daytona that doesn't know cars are on the beach. So what the court said is basically, I'm ruling that if she knew cars were on the beach, which is all she said she knew, that yes, cars were on the beach, that you can't sue. But this is where the problem lies, and I'll be closing here quickly. When you look at the whole set of facts, which we need to do, my client came down and laid down to rest in soft sand with headphones on, reading a book, believing she did not have to look out for cars, believing she was safe because of where she was, believing she was safe because cars stay up where the cones are, Judge Nardella, where traffic lanes are created. And this truck was not in those traffic lanes. Those had been abandoned. And in fact, the truck was told to get out of the traffic lanes. That's where the water is. And of course, even if they hadn't been told that, nobody wants to run their vehicle through incoming surf and get the salt up into their vehicle and ruining their vehicle. So the totality of the case is very simple. We not only have a Ralph case, we have a Ralph case that is now importantly changed by the Coastal Zone Act, which then gave an entity like the county the power to assume that control, to hire people to make those warnings, to hire people to put up the cones or mark areas to give these people that are sunbathing a safe place to sunbathe. And they didn't do any of that. And excuse me. Yes, Your Honor.
When you say we have a Ralph case, the county alleges that Ralph was only decided on one allegation of duty, not the two allegations of duties you've made in this case. Can you address that?
Yes, I sure can, Your Honor. We essentially pled a Ralph case. We pled and have well pled in the complaint that the county, in this case, failed to warn our client of the dangerous condition of the mixture of cars and sunbathing on the beach, the Ralph issue. Because the facts were, as we would learn them, and I feel I'm required to do it, when the facts developed that as we took depositions, that the county, in fact, would create these rules and have law enforcement directing where traffic would go and putting up cones and signs. That wasn't apparent. That's what I'm trying to explain to the court. We didn't have that in Ralph. Ralph was just an open beach back before we had all this type of care and concern and attention to safety. And so I then pled, it's not only a failure to warn case, but it's also a failure to maintain the property that they then had control over case, a la Butler. So there's two theories of liability. And if I go to trial in the court, if the court said, well, yes, Mr. Ebbets, we agree it's a Ralph case, you don't have a negligent maintenance case or on the secondary theory, I still get to the case. I still get the case to the jury because it's still a Ralph case. And nothing.
You've got about 3 minutes left of your time. Do you want to save the rest for rebuttal?
Thank you very much. Yes, Judge Trevor. Thank you.
All right. Mr. Carroll, whenever you're ready, sir.
Yes, sir. Hey, please the court. My name is Fran Carroll. I represent the County of Volusia in this matter, and we're here today to ask the panel to affirm the summary judgment that was correctly entered on our behalf with regard to this claim. Just as a summary of the grounds that summary judgment was granted, the summary judgment was granted on several different grounds. The first ground is that section 380.276 sub 6 bars this action as the plaintiff's theory, as shown by the allegations in the complaint, rest on the argument that a dangerous condition was created when the incoming tide caused vehicular traffic to be drawn closer to beachgoers. Number two, the trial court granted summary judgment on the negligence or liability of the county in failing to close the beach earlier. There's no theory here with regard to directing cones or putting cones up or anything like that. The theory here is that the county was liable for failing to close the beach earlier, because the undisputed facts show that the decision to close the beach had already been made at the time of the incident. So the question there is broken down into two separate parts, both of which are distinct and not interchangeable. The first question is whether the county owed a duty as a private individual would to the plaintiff to close the beach earlier. And our position in trial court correctly decided that the duty owed to close the beach would be a factor or a potential ground based upon the public duty that the county owed to protect its citizens, which under Trianon Park would be a category 2 function. Assuming that there was a private duty of some dimension owned, the court then decided that as a matter of law, these are all questions that are a matter of law, there's no question of fact involved in this, is that the decision to close the beach encompassed a basic governmental objective or policy, which was to keep the beach open. As opposing counsel indicated, the beach driving had been available or existent in Daytona, in Volusia County for a millennium, for 100 years. And this was a basic governmental objective, which was allowed under the statute to be accomplished. The decision to close the beach relies upon several different factors, such as the weather, the amount of people that are on the beach, the traffic, and several other environmental conditions related to nesting sea turtles. There's several different conditions that come into play, several different factors, all of which Captain Etheridge took into account. It's undisputed before he made the decision to close the beach. The beach was closed on a Labor Day holiday, which he indicated large crowds were expected. So this is a traffic control condition. It's nothing to do with leaving aside the beach being the venue. The case law is clear. That's the nature of the act that governs, not the location, as is being suggested here. The location is not relevant. It's the nature of the act. And the nature of the act here was the closing of a access or roadway to the beach. And just like the county would close A1A or any other roadway. The sovereign immunity is the basic policy decision embodied by Captain Etheridge and illustrated in the Trianion Park Category 2 discussion, where Trianion Park says there's many acts inherent in the act of governing that would be not actionable, such as the decision to arrest somebody, which is Everton, the decision to hold somebody in protective custody, the decision to fight a fire, as in the Palmer case cited in the Trianion Park case, the decision to fight or combat a riot, as in the Wong case. These are all inherent discretionary acts that go to the act of governing. And the trial court correctly decided that sovereign immunity would bar the liability of the county in not closing the beach earlier. The next ground would be on the doctrine or the of open and obvious condition, and as it relates to the duty to warn. And I'll just read basically from the Ralph decision. The Ralph decision says, the scope of this opinion is narrow. We do not resolve the issue of whether the city, in fact, breached a duty to warn. Resolution of that issue concerns the readily apparent nature of the danger in this particular instance. So we file our motion for summary judgment based upon the readily apparent nature of the danger in this instance. And if you take a look at the allegations in Ralph in footnote 1, paragraph 19, the allegations of the complaint in Ralph is that Orla Ralph was down at the water's edge when this happened. She was alleging that she was near the water's edge of the Atlantic Ocean. So that's a much different case than here. The duty to warn is obviated by the obviousness of the danger involved here. And councils indicated that they should warn, that the county would have a duty to warn of cars parking on the beach. Well, the undisputed facts from the plaintiff herself state that she knew that cars were on the beach. She had gone to the beach on several occasions before this, over a period of a month or so, 3 to 4 times a week is her testimony. She actually parked on the beach herself. She actually utilized the beach for parking herself. So she knew that cars parked on the beach. And she knew that the tide was coming in that day, and that's the reason why she didn't park. So she knew all these things that any warning would not have given her any further knowledge of. And the last part of this is she actually, as opposed to the argument here, she knew that cars were driving on the beach. And in fact, she testified in the second deposition, testified expressly that she saw the truck that struck her come off the beach ramp and head right onto the beach in the direction that she was sunbathing. So she actually did not even beyond even knowing that their cars were driving on the beach and parking. She knew that she actually observed the car that struck her. In addition to that, counsel talks about the fact that no one asked her the question of whether or not she knew that cars would be parking in that specific area. I would suggest that it would be the burden of the plaintiff to produce in some form an affidavit, some deposition testimony, something in the record that would show that this is what I didn't know, and this is the danger that's not apparent to me. It's the burden of the plaintiff to demonstrate that there's an issue of fact here. And there's nothing in the record that Miss White offered, no affidavit, nothing that shows that there was a danger of which she was not aware, that she would have done something about had she been aware. In other words, she didn't testify, I would have moved to a different spot. The actual testimony regarding her being safe, and I'd like to address this for a second as well. The second amended complaint was different than the third amended complaint. The second amended complaint alleged that there was a lifeguard on duty at the time of this incident, and that the lifeguard should have issued or yelled out a warning of some dimension. That's a totally different theory than what we're here for today. And that's the complaint that the judge Judge France denied the motion to dismiss on. On the eve of the motion for summary judgment, when it became apparent that there was no Volusia County lifeguard in the lifeguard tower, the plaintiff amended their complaint to allege this theory that we're here for today. So the warning that she alleged would need to be given at that point was because she thought there was a lifeguard in the tower that was connected with the beach, the lifeguard tower. As to the effect of the statute, and Butler on this case and the duty to be derived. Apparently, the plaintiff is arguing that the fact that the county was given, or local control was given to municipalities and counties to control the beach, somehow changed the analysis that needed to be undertaken with regard to a public versus private duty. The Butler case and the Bro case, which is also cited in the brief, both are limited in their scope. They are concerned with the operation of a swimming facility. And both of them specifically held that the operation of a swimming facility would give rise to liability because in those circumstances, for the swimming facility, the duty of the county would be no more, no less than the duty of a landowner under similar circumstances. By no stretch of the imagination was these holdings extended to the entire 18-mile length of beach in the county of Volusia. In fact, if you take a look, Brow was a 4-3 decision. If you look at Judge Lewis's concurrence, he specifically states that the holding in this case was not extended to the thousands of miles of beachfront property of Florida. He specifically states that. He specifically limits the holding to instances where the county, or in this case, the city of Miami Beach, erected a swimming facility pursuant to a long-range agreement, a long-term agreement it had with the state, and did several things to encourage swimmers to use that area. In other words, one of the things that the Brow concurrence pointed out was this was not a situation where swimmers would randomly come to the beach. They were invited there by the city through the various things that they did, such as restrooms and things of that nature. And the suggestion that liability insurance was some sort of recognition by the legislature of the fact that now the county has an unlimited duty to maintain the beach, I think is a little not well taken, in the sense that liability insurance could be purchased for a number of reasons, not the least of which is the fact that the county, through the Beach Patrol, operates vehicles. And they would have the option to purchase liability insurance if they struck somebody, which has happened on occasion. They would also purchase liability insurance if something happened with the pier, which would be an area that they did operate. That's not, something, the existence or the ability to purchase liability insurance is not germane to the issues in this appeal whatsoever. And I would like to also address, or I would like to point out, there are two procedural issues that we've not discussed, which is the law of the case doctrine, which was prominent in the brief, as well as the waiver argument. And those are two, in our view, red herrings that are not relevant to the appeal. I think those issues were adequately addressed in our brief. But if the panel has any questions as to the applicability of either one of those issues, I'd be happy to address them. So basically, that concludes our argument. So in conclusion, the trial court should be affirmed. It was correct. The statute 380.276 subsection 6 applies, because the whole basis of the plaintiff's cause of action is that the incoming tide caused a dangerous condition to occur, which was the compression of cars with beachgoers, which causes this incident to occur. So the it's clearly within his own allegations. He comes within the ambit. Ms. White comes within the ambit of the statute.
Mr. Carroll, I have some questions about the statute. Mr. Ebbett points to the phrase "caused by," and I wanted to talk about that. When we look at that phrase, are there any principles in other areas of the law that you would apply to understanding what causation means in that statute? For example, we have, legal proximate cause in tort and insurance. We have efficient proximate cause was a doctrine at one point. Concurrent cause was a doctrine at one point. What do you think that causation element in the statute requires in this?
I think that if you apply the principle of statutory construction, which is to give unambiguous words its common meaning, the word cause would mean as I pointed out in the brief, would be a contributing effect to the incident, to the injury here.
So if multiple perils create a loss, and at least one of those perils is the change of surf, statute applies. Is that right?
Yeah, I would, yes, in the sense of the statute, first of all, not only applies to the changing surf, it also applies to other naturally occurring conditions on the beach. So certainly the incoming tide is a naturally occurring condition. So unlike this case, I believe Your Honor is suggesting that if there were several different causes, we would of course it'd be looking at intervening causes and as well. But if it's a concurring cause, it definitely would come within the ambit of the statute, because it's a cause. And
what if it's an efficient proximate cause? What if it sets a chain of events into motion? And I
would say that the efficient proximate cause would be encompassed within the term cause. The statute doesn't limit liability, it just says cause. And so efficient proximate cause would be coming within the ambit of the statute. That's what happened. That's exactly what was pled in this case. Without the high tide, there'd be no cause of action for liability, because there'd be no need to close the beach. And without the incoming tide, there would be no dangerous condition of which the plaintiff alleges gave rise to the duty to warn. So the whole key, the whole basis, the foundation of this theory is the incoming tide. And I see where I have some time left. If there's any other questions from the panel, I'll be glad to entertain them. If not, thank you.
Thank
you, Mr. Carroll. Mr. Ebbets, you have a little bit more than 3 minutes. Go ahead.
Please, the court. I'd like to address, if I may, Judge Nardella's question to Mr. Carroll about causation. Causation, of course, is defined by Florida law, but is codified in the sense that we have a definition of it on our standard jury instructions, which we follow. And as the court noted, there are 3 portions of causation, at least in a negligence case. Legal cause is, and this is important, if it is direct and in natural and continuous sequence produces the loss or damage complained of. And that's not what happened here. The surf didn't injure my client. My client was injured because of the county's essential failure to warn my client, you better not lay in that soft sand with your eyes closed, with your headphones on, because a truck may come up there or cars can come up there when we let them do that and run over you. And that's Ralph. And that's interestingly, if we look
Mr.
at
Mr. Ebbets, was there any other reason to change the traffic pattern on the beach at the time of the accident other than the changing tide?
Was there any other reason, Judge Wallace, to change the traffic pattern?
Yes.
Well,
first, to operate differently on the beach other than the changing tide.
If the way it developed, their control of the traffic with the lanes was controlled, and the closure of the beach was controlled by what the tide was doing. So to answer the question directly, I don't think there was any other reason for changing the cones or the placement of cones except relevant to what the tide was doing to shift where the cars would be permitted to drive. I have to say that's true.
Okay. Thank you.
And then I only have a minute left. So let me just say that I think that Butler, which is a 1986 case after Trianon, after Ralph, which is a Supreme Court case, again, is where we must land, where the trial court originally landed. And that is once, and then again, it was a beach. It was Sarasota Beach, but they then said this area of the beach is where we're going to allow swimming. And that's how it became a swimming facility in the case. And it said once it did that and it created that, and it's exactly what the court says. And the duty of care is no different for a public owner than a private owner. In this instance, the public owner did not create the specific dangerous condition, but did create a designated swimming area where the dangerous condition existed. And then we tie that back to Ralph, and it says what the dangerous condition is: the lethal mixture of cars and sunbathers laying in the sand. And that's what this case lands on. That's what this case is about. And then very quickly, a lot of what my colleague did was argue the facts. And then back to you, Judge Nardella and Judge Wallace, on this question of the surf. Causation is a question of fact for the jury. That's Supreme Court. That's seminal. And so we had fact issues here. And the very first thing I said in the brief was, fundamentally, we had facts that the jury—
You're out of time, Mr. Ebbets. Would you please conclude, sir?
I'm done, Your Honor. Thank you.
Fair enough. Well, thank you very, very much. I thought this was well argued this morning.